Thank you, Mr. Speaker. Since the Liberals formed government in 2015, this country has seen a steady and alarming increase in major crime. Violent crime up 55%, homicides 29, sex assault 76, firearms 131, and extortion a whopping 330%. This government's tireless efforts to prioritize the rights and freedoms of the accused at the expressed expense of victim and community safety is the problem. In 2019, this government initiated bail reform in this country by amending the code to introduce the principle of restraint, which immediately instructed judges and justices of the peace to prioritize the release of the accused at the earliest opportunity on the least restrictive conditions. And contrary, Mr. Speaker, to a false Liberal narrative, neither the Supreme Court in Antic or Zola instructed the federal government to amend the criminal code to add the principle. From the perspective of a former Crown attorney, this amendment meant that regardless of the nature of the charge committed by the accused, its impact on the community or victim, regardless of the criminal record, which could show a pattern of breaching court orders or being found guilty of the same offense, and most importantly, regardless of the number of prior bail orders the accused may already be subjected to, this government instructed these judges and justices to release the accused. This was the origin of catch and release we now have in this country, where violent repeat criminals circulate through the justice system with regularity, offering up false promises of bail compliance. In 2022, the government weakened the criminal justice system again and exposed Canadians to immense risks with the passage of C-5. Notwithstanding the long-established position of the Supreme Court that mandatory minimum penalties do not necessarily violate the Charter, the Liberal government repealed mandatory minimums for serious gun and violent crimes and expanded house arrest for all drug offences and serious violent crimes. In 2023, after hearing from numerous stakeholders regarding the stolen vehicle crisis, this government brought in Bill C-48, their second attempt at bail reform. A core feature of the bill was to introduce a number of new reverse onus provisions to gun and other serious violent offences. The key messaging was this meant that violent repeat offenders would be detained, that this bill would contribute to the safety of Canadians. Well, Mr. Speaker, the opposite was the effect. The rising crime state clearly establishes that the bill failed miserably in achieving its goals. Over the course of the last 4+ years, we've heard from premiers of all provinces and territories, police chiefs, presidents of police associations, mayors from across the country, and several community victim advocacy groups pleading with this government to exercise its #1 priority to keep Canadians safe and to implement immediate bail reform. And what was the response? Well, according to David Lametti, the former Minister of Justice, he proudly proclaimed that he did deliver bail reform, completely oblivious to the crime and chaos happening all around him. Lametti was later fired, and the government appoints Arif Virani. His first comments after his swearing in reminds Canadians that it's all in their heads that Canada is less safe. He too reminds Canadians that he delivered bail reform through the passage of C-48. In the 45th Parliament, we've heard from our Public Safety Minister that our Canadian bail system is sound, that it is working as it should. Later, we heard from our Justice Minister blaming the provinces for all the bail problems that we have, and that Canada is not the Wild West, the very same weekend, Mr. Speaker, that saw violent home invasions that led to the death of homeowners. Canadians and our stakeholders couldn't wait any longer. A recent Abacus poll conducted this past September showed that 79% of Canadians feel that it is too easy for serious offenders to get bail. And that is precisely why my colleague from Oxford introduced his Jail Not Bail Act. I'd like to take the opportunity to point out, notwithstanding the false narrative from the Liberals, that law enforcement unconditionally endorsed this bill as offering the best opportunity to rebalance the bail system, to prioritize community safety over the release of violent repeat offenders. What does the bill do? Well, the principal feature is to repeal the principle of restraint and replace it with the principle of public and community safety. The practical effect is to end the default to release culture, which has created the bail crisis we have in the country. The priority is the safety of communities and victims and not the release of violent repeat offenders. This is a marked distinguishing feature of Bill C-14, which still preserves in various degrees the principle of restraint. The bill also creates a list of major offenses which would trigger a presumption of detention, regardless of whether or not it would be a reverse onus charge. For major offenses, peace officer release is unavailable. The bill expands reverse onus to several violent offenses, including firearms, sex offenses, kidnapping, trafficking, home invasion, break and enter, robbery, extortion, and arson offenses. The bill adds surety and non-resident safeguards, completely absent in C-14. It bars naming as surety anyone convicted of an indictable offense within 10 years. It also requires consideration of non-residency and flight risk and mandates passport denial for non-residents upon release. Another significant feature of the Jail Not Bail Act is an adjustment to the risk threshold analysis under the secondary grounds for detention under Section 515 of the Code. The current test is where detention is necessary for the protection and safety of the public, including victim or witnesses, or to prevent the commission of a further criminal offense based on the substantial likelihood of such an event occurring. Substantial likelihood has been defined in case law as a real and significant probability of a particular outcome occurring. This was never viewed as an onerous test from Crown Counsel, as they often ask the justice to consider the criminal record of the accused and to look for patterns of conviction, either for the same offense or conviction for breaching court orders, such as bail, probation, and conditional sentences. Jail, not bail, lowers that secondary ground threshold from substantial likelihood to reasonably foreseeability in assessing risk of reoffending or interference with justice. We've all heard about the tragic yet preventable murder of Bailey McCourt, a young Kelowna mother who was bludgeoned to death by her ex-husband with a hammer in broad daylight. She was murdered the very same day within a few hours of him being convicted of assault and uttering threats. He was released on bail pending sentence with the obvious condition that he not have contact with Bailey. Jail Not Bail Act provides for the expiry of the interim release of an accused upon their conviction of an indictable offense while they await sentencing. The finding of guilt by a justice expunges the presumption of innocence as guaranteed by the Charter. This provision in the Jail Not Bail Act, Mr. Speaker, is simply common sense. This country has long awaited real, immediate bail reform. The Liberal government created the mess we find ourselves in, and now do we really expect them to provide the solution when they had the last 10 years to reverse the course from their hug-a-thug mentality to exercising their #1 priority, being the safety of all Canadians? Law enforcement across this country has hailed jail not bail as the common sense solution to keep communities and victims safe while ensuring that violent, repeat criminals are kept in jail where they belong. I urge all parliamentarians to set aside their political ideology and to make it their priority to pass the Jail Not Bail Act. As I have said numerous times, inside and outside this House and at town halls right across this country from coast to coast to coast, community and victim safety ought not to be a partisan exercise. Let's get this passed. Thank you, Mr. Speaker.